the meeting of the Task Force on Mandatory Minimum Sentences to order. I am going to switch around the agenda just a little bit. We're going to start with item number 2, membership update with Morgan Coons, because that will make item number 1, the roll call, makes sense. Morgan, if you wanted to, I understand you have an announcement for us.
Thanks everybody. I just wanted to let everyone know that my employer, the Hennepin County Attorney's Office, has left the Minnesota County Attorneys Association, and the spot that I was filling on the task force was an appointment by the MCAA. And since the Hennepin County Attorney's Office has left, the MCAA has decided to make a change in their representation on this committee. And so I'm no longer going to be a member of the task force. I'm being replaced by someone from Ramsey County, Mark Hasse. I think I can't see there. Mark, are you there in person?
I am. Yep, I am here, Morgan. Thanks.
So Mark is just really experienced prosecutor who's going to be able to continue the great work that we've all been doing. I wish that I would be able to see this through with you all. I think this is really, really important. I'm really proud of all the work that we've all done over the last 7 or 8 meetings, and I'm going to be popping in and observing as much as I can. I'm also absolutely willing to continue to help in any way that the task force thinks that would be beneficial. So I just wanted to come on here and thank everyone so much and express that I wish I could see this to the end with y'all, but Mark's going to be a great replacement for me. So.
Well, Morgan, I just want to say how grateful I am to your service on the commission, particularly me as an individual, because of your service as my vice chair. It was really, I mean, there were quite a few times when I was kind of stuck or just wondering which way to go or needed advice or whatever. And you were always there for me. And I really appreciate that. Really excellent vice chair, and appreciate your service. I also know, that you are kind of under the curse of living in interesting times, and you're quite busy there at Hennepin County anyway. So I appreciate all the work you do at Hennepin County. Keep it up, and thank you for your help on the task force.
Thanks.
Mark, welcome. I've had the pleasure of kind of bumping around shoulders with Mark since I started working at the Sentencing Guidelines Commission about 12 years ago. He's one of those guys who can't hold down a job. I mean that in a good way. Like always, getting more and more interesting roles that he's jumped into. And Mark, do you want to just introduce yourself a little bit to the task force? And
yeah, thanks, Nate. Good to see you and everybody else. I do know a lot of you already. I'm looking forward to meeting some more. I am also, sorry that Morgan's not able to stay on, but we already spoke, and he gave me his insights so far, and I know that he'll continue to do that as needed. I did watch the last month's meeting to try and catch up, and I'll continue to try and get caught up. I've, I wouldn't say I'm an experienced prosecutor, but I am experienced in criminal law policy. And so I hope that experience from a number of different avenues will be helpful to the task force. I'm used to working in these types of groups collaboratively and trying to get, to a good result. And I really look forward to that. It's actually mandatory minimums were what got me involved in this work 25 years ago, looking at what was happening in the federal government with federal mandatory minimums and problems those were creating. Thankfully, those have been rolled back some now. And I'm also looking forward to representing the County Attorneys Association. So thanks.
All right. Well, thank you. Thanks for being willing to serve on such short notice and sort of at this kind of critical juncture as we're about to make a turn here and start coming up with practical ideas that we can present to the legislature. So now let's move on to the roll call. Donna, would you please call the roll?
Shane Baker.
Here.
Jeremiah Carlson.
Here.
John Donovan.
Here.
Mark Hasse.
Here.
Dale Harris.
Here.
Why do I have all these troubles?
Amber Johnson.
Here.
Kelly Mitchell.
Here.
Mark Osler,
Here.
Nate Reitz,
Rights
Reitz,
here.
Ken Sass, Ken Sass, Nick Sasser,
Here.
Rob Stewart, Rob, you're not coming through. I see you as here.
Did that now? Can you hear me? No?
There we go. Now we can hear you.
Okay, sorry.
That's okay. Ashley Stewart Scriffith.
Here. Hear me?
Yes.
Okay.
And that is a quorum.
All right. And then moving on to approval of the 2026 minutes and today's agenda. Did anybody have any corrections to note on the 2026 minutes that were sent out? Any corrections? Hearing none, the minutes will stand approved as drafted. Any objections to the agenda? I'm not going to formally adopt the agenda, but just wondering if there's anybody who would like us to move in a different direction today. Okay, we'll proceed informally on that basis. All right, the next item on the agenda is election of the vice chair. We don't have to elect a vice chair today. I know this is sudden. However, time is short. We're at in 4.5 months, it'll be August. I know that seems surprising given a week with 3 snowstorms in this state, but it's true. So I checked on the calendar. So it probably would be a good idea to advance with a vice chair at this time. But if we're not ready for it, I know it's all sudden. We many of us just learned about the vacancy a few minutes ago. So if you want some time to think about nominations, we could push this off till the end of the agenda if you prefer. Otherwise, if anybody has any ideas, any nominees, self-nominations are fine for the role of vice chair. Well, has anybody thought about being the vice chair and would like to just sort of air it out? Or anybody at all interested?
I can talk. You had a meeting with the subcommittee chairs and you had asked if any of us would be interested or willing to serve as a vice chair because we meet anyway to talk about the work that we are doing on the subcommittees and to help shape some of the agendas. And I'm willing to serve, but we're both from the Sentencing Guidelines Commission. I know I also serve the DOC in my role. So I thought that might be weird for us to both be in this role, but I'm happy to do it if people are fine with that.
So just so everybody's clear on our roles, I'm the executive director of the Sentencing Guidelines Commission. So I lead the staff of the Sentencing Guidelines Commission. Kelly Mitchell is an assistant commissioner of corrections, but she's also the chair of the Sentencing Guidelines Commission, sort of as a additional duty. So she's effectively my boss. Incidentally, she's also my predecessor. So before I took this role, she was the executive director of the Sentencing Guidelines Commission these many years ago. So that's so I guess the concern about having Assistant Commissioner Mitchell as vice chair would be that sort of we're kind of loading the Sentencing Guidelines Commission influence kind of heavy on this task force. So I think that is a valid concern. I also think that Assistant Commissioner Mitchell will be very qualified to be the vice chair as well. So I think I'd open up to the discussion, is the task force, would the task force be concerned about having that much influence in the chair and vice chair roles for this task force from the Sentencing Guidelines Commission organization?
I would like to move to nominate Kelly Mitchell to be the vice chair.
Okay.
I will second that nomination.
All right, so we have a nominee for vice chair, Assistant Commissioner Mitchell from the Department of Corrections. Any further nominations? Or any further discussion, honestly? I'd be happy to entertain discussion if there is any concern about this, because what's going to happen if nobody else gets nominated, and based on the deathly silence that preceded this nomination, it sounds like maybe nobody else will get nominated. I'm just guessing. That Assistant Commissioner Mitchell will be elected as vice chair by acclamation because nobody else nominated anybody. So so now is a good time to speak up. If you have any concerns about that, I'd love to air it out. Okay, well, any other nominations? Third time, any other nominations? All right, hearing none, I'm going to close nominations. All right, I'm closing nominations, and I'm going to declare that Assistant Commissioner Mitchell has been elected as vice chair by acclamation. Thank you, Assistant Commissioner Mitchell. This does raise another issue, and that is that you are currently the chair of the Stakeholder Engagement Committee, which maybe I could say you've sort of done the lion's share of your work, or at least it's happening right now in getting sort of the vendor off the ground in terms of stakeholder engagement. Do you want to pass the baton on to somebody else, or do you think you're okay in both roles for the time being?
I'm fine doing both. It's like you said, most of the work has been done to get us to the point we need to get to. So I'm fine.
Okay.
continuing to do that work.
All right. And I did have the vice chair lead the public safety portion of the discussion, which I'm wondering if you'll be interested in doing that as well. I know that's
not fair.
yeah, tough. All right. So, actually, is Julia Laskarensky online?
She is, can you elevate her? She's an attendee. Yeah.
He's now a panelist.
Okay. Dr. Laskarensky, are you there?
I am here.
All right. Dr. Laskarensky, thank you for agreeing to present to the Task Force on Mandatory Minimum Sentences today. Welcome to the task force. Yes.
Nate, I don't think I knew I was presenting today. I'm
Oh,
sorry.
really? Oh, snap.
Chairman Wrights.
I'm sorry. That's my fault. I thought I communicated that. I did not follow up with you this week, though. I'm sorry about that. Okay.
I am sorry. I should have, I know there was some interest in me presenting last time, and I didn't realize you had made time on the agenda for me to present today. Yeah, I'm really sorry. I can certainly come back next time.
Sure. Well, that's embarrassing. Well, I apologize. It's my fault. I didn't coordinate that. This was, yeah, it was regarding the research that you had done for the Sentencing Guidelines Commission regarding sort of a limited version of stakeholder engagement that you had done with prosecutors and defense attorneys regarding 60911 and sort of how that worked in practice. But
I would be more than happy to present on that, and I think that information would be hopefully very valuable to you. But I would not be able to present on that right now.
okay. All right. Thank you. Sorry about that. Yeah, that's I think my fault. I was gonna reach out to you. I thought I had, but I apparently did not. So I apologize to the task force for that. And to you, Dr. Laskrowski, thank you for being here. Failure to register information from Assistant Commissioner Mitchell, Vice Chair.
What,
See, was that not a thing either? All right.
no, she's doing both, like.
Oh, she was doing both.
Both, so just for everyone's grounding, when the Sentencing Guidelines Commission is in the process, or has been in the process of doing a comprehensive review of the guidelines, and as part of that, we had a team from the University of Minnesota doing both quantitative and qualitative research for us. And so what Julia Laskrowski did, Dr. Laskrowski did, was some stakeholder input on the offenses that had the highest mandatory minimums, and they also are, the highest departure rates, and they also intersect with mandatory minimums. So the 60911 and failure to register. And she had done some work on both of those topics and brought that to the commission. And I thought it'd be valuable for this committee to see what had been presented to us. So the ask is for her to take those. They were two separate presentations to the commission. The ask is for her to take the relevant information for those two mandatory minimums and to bring it here. So I can connect with her and make sure that we do that for next time. So.
All right. Well, again, I apologize to the commission, or to the task force. I don't know. I'm thinking of, I used to love to read the funnies when I was a boy, and I'm thinking of reading in the Sioux Falls Argus Leader, a cartoon called Willie and Ethel. And it's about a married couple named Willie and Ethel. And Willie has got a picture with the saying in it. It says, "Assume nothing," that he's hanging on the floor, on the wall. And he says, "Hand me the hammer, Ethel." And Ethel just kind of looks at him like, "What are you talking about?" So clearly he was assuming that Ethel had a hammer. I apologize for this, Dr. Laskrowski. All right, so we're going to move on to the reviewing of the framework for evaluating policy impacts and recommendations. So this is, so the goal here really, just to kind of recap where we are, we're trying to sort of end the diagnostic phase of this task force work, kind of getting ready to turn a corner next month, as I said. And we're borrowing a framework that was developed by Ashley to evaluate current policies. Now, this framework, as I understand it, Ashley, was designed really to evaluate what we're recommending, right? So it's something that we want to eventually apply this to whatever recommendations we have, and to see what our recommendations stack up against these 7 criteria here. But it's also, I think, fair to turn this framework on the existing status quo, right? I mean, and see if, and hopefully what we end up recommending improves on the status quo. So this is really kind of diagnostic at this point, and to see first of all, are there problems with the status quo? And second, can we be specific on what those problems are? And then this will, I think, really inform what we end up recommending to kind of fix those problems. And it will also answer the question of why we're recommending changes, assuming that we do recommend changes. And I don't want to prejudge anything that'll happen as we turn the corner in our April meeting, but assuming that's the way we go, this is really an important basis for doing that. So I've asked the 3 committee chairs to take 2 questions each, 2 of the 7 questions each, and then all of them to take the first question, the public safety question. And I thought it was really helpful last time when former Vice Chair, when Morgan looked at this and sort of started by defining public safety. And I think that's something that can have a lot of definitions. So Vice Chair Mitchell, before you just start that conversation. Tell me what you think public safety even means. Because I know that Morgan had some ideas on that as well. And it was, I think there's a lot of different ways to look at that. Probably because they're all true. I mean, there's a lot of different components to public safety.
Yeah, I think it's a loaded question in many ways.
Mhm.
You know, because I think that there are a lot of ways to achieve public safety. And, you know, I think public safety is really a situation where we are doing what we can to both prevent future criminal behavior and to rehabilitate individuals who have committed criminal behavior. And we just recently at the Sentencing Guidelines Commission sort of had this philosophical conversation about what public safety means, because our statute requires us to make public safety a primary consideration in establishing the sentencing guidelines. But when you think about, you know, sentencing itself, so I'm sort of going in a little different direction, but when you think about sentencing itself, like sentencing can do many things. Like it can result in incapacitation, right? A person could be locked up as a result of their sentence, but it can also result in rehabilitation, which, you know, might be the situation where we think keeping the person in the community but providing treatment and services is the best approach to preventing future criminal behavior. There's also a retributive, you know, purpose to sentencing, just sort of, you know, making sure that that individual received the punishment that they deserve for that offense, and that they're, you know, and that inspires public confidence, right? That we are working to hold people accountable for offenses that they have committed. So I think that what's loaded about the question is that public safety isn't one thing. It's like all of those things together, and it's sort of trying to figure out from case to case, like how do we best achieve public safety? How do we best respond to this behavior in trying to, you know, like overall prevent future crimes?
Just a couple of housekeeping matters before we begin. So the basically the task force decided to look at 4 categories of mandatory minimums. And really how you divide up the mandatory minimums is somewhat arbitrary, but basically taking the 6 and 9/11 mandatory minimums and dividing them into the you know, possession of a firearm or ammunition by someone who's previously committed a crime of violence, that's defined in Chapter 624. So then, and that's a lifetime ban, and it carries a 5-year mandatory minimum. So it's very simple. It's also one of the biggest impact mandatory minimums in terms of the number of people who are convicted of that. And then the other mandatory minimum that we looked at last year is the other 6 and 9/11 mandatory minimum, which is committing a listed crime in subdivision 9 of 6 and 9/11, either with while possessing a firearm or while using another dangerous weapon. And then there's several different mandatory minimums for that, and there's kind of a complex scheme on whether or not those mandatory minimums are waivable or not, whether they're hard mandatories or soft mandatories. But for sake of simplicity, we kind of grouped all those into one, committing a listed offense with a weapon. And the other 2 mandatory minimums, which are much less, I would say, significant in terms of the number. I don't mean that they're insignificant for the people for whom they're affected, but I mean in terms of just looking at the system and the number of people who are affected by them. The other 2 mandatory minimums that we're looking at today are knowingly violating a predatory offender registration requirement or intentionally providing false information to basically an agent in connection with the predatory offender registration. And that mandatory minimum carries 1 year and a day for a first offense and 2 years for a repeat offense. Those are waivable mandatory minimums. And then, so that's one bucket, the predatory offender registration mandatory minimums. And then the other the final bucket is drug mandatory minimums, which consist of aggravated first degree controlled substance crime, which is carries a minimum of 86 months, but it can be higher than that. It's essentially whatever the guidelines grid time is becomes the mandatory minimum, and it's not waivable. And you can't even use the lower range in the you know, each guidelines grid square contains a range, 15% down, 20% up, that the judges can discretionarily use, but that's off limits for this particular mandatory minimum. And then there's a 65 month, also not waivable mandatory minimum. Well, it's not waivable for sale. It's sometimes waivable for possession. And that involves high amounts of controlled substance crimes in first degree. And finally, we have repeat first and second degree drug crimes. So if you commit a first and second degree drug crime after having been convicted of one, it's 4 years for first degree, 3 years for second degree. Those are not waivable.
That's a question, Nate.
Yes.
I seem to recall in 2013 or 14, well, I know that there were some changes to the drug sentencing,
Mhm.
and I think there were some mandatories added at that high level.
Right.
I'm not sure, we don't, and maybe you've already presented on this. I'm just curious if you've looked at how much judges have used those since they were created.
I mean, we have presented some data on the use of mandatory minimums. I think that was in our January data presentation. So I don't have it committed to memory, but
Okay, I can go back and look at
I
that.
think that's there. But yeah, there's just a whole bunch of information that MSGC research staff put out on all these mandatory minimums. Somebody, I think it might have been Judge Harris, but somebody pointed out, one of the most interesting findings from that was how the departures from some of those mandatory minimums kind of stair steps down as the criminal history score gets longer. So I think that's something that's really stuck in my mind, and I think we'll be bringing up next month. Vice Chair Mitchell, are you willing to take us through analysis of public safety for those two mandatory minimums, the predatory offender registration and drugs?
Are you just asking me to lead the conversation?
Yes. Yeah, just lead and also if Wilder could take notes and project those notes on the screen during this discussion, that'd be great. Just so we kind of all see.
I think Jennifer's.
Yep, I'm getting it ready right now, so you should be able to see it.
Okay, awesome.
Okay. So I think Morgan went subcommittee by subcommittee last time, if I am recalling correctly. So Rob, did your subcommittee get a chance to meet on this?
So we did not actually. We were supposed to meet this morning, but we had some issues with getting the meeting open and activated. And it kind of turned into a fiasco. So we did not get a chance to have a conversation about this.
Well, do you have any thoughts as chair of that group?
About which question? Which question? The first one?
Predatory offender registration. There's 2 mandatory minimums there. I think you just went through them already.
Yeah.
So predatory offender registration, what's the public safety? Does that policy promote or undermine public safety?
Yeah. So how well does the policy of having a 1-year mandatory minimum for first-time violations, 2 years for repeat of the predatory offender registration statute, how well does that promote public safety? So I'll just start the conversation here.
My group did meet.
Okay.
Oh, okay. Let's go with Mark then. Let's start there. Go
Okay.
for it.
Yeah. So on these 2 questions, we met this morning, had a good discussion about this. So first of all, on the predatory offender registration, we also were charged with talking about fairness and culpability, the proportionality question. And so there's a lot of overlap between those 2. So probably address both right now. But first of all, on the predatory offender, one of the concerns, there was a lot more concern about first offenses than second offenses. And that's because of housing instability and the problems that creates. You know, basically people who come out and they're couch surfing. And that is a factor many times in what happens. There's a lot of departures in this area, which probably tells us that the mandatory isn't something that's being directive in the way it's intended. A criticism of that first offense mandatory too was that it's too much of a one size fits all punishment. And there are a couple of the things that come into play are that aren't accommodated by the mandatory. One is the length of the delay between the registration and the punishment or when the person does report. Another is that it doesn't distinguish between the more serious offenders and the less serious ones, particularly, violent offenses as opposed to other types of offenses that fit that category. And another concern too is that there are a lot of what triggers the violation can vary a lot because of there's a lot required for the registration. If you don't have a school phone number on there, that's a very different thing than not registering at all, but it can be lumped together under that mandatory. So there, so that's those were the major concerns. So I think overall, as I said, much more concern for the first offenders, and that's something we should look at pretty closely.
Mark, are you thinking of like a legislative recommendation to tune up the statute a little bit so there's a distinction between what the violation is, or would that be too complex?
Well, I mean, this is the bigger question. Or do we ask just that the mandatory be confined to second offenses?
So, sorry.
No, you're good.
I was just going to say the main justification that I got when I was on the predatory offender statutory framework working group, I think that's what it was called. I think I might be getting that mixed up with a different committee, but the main justification from law enforcement seemed to be that this mandatory minimum they thought was instrumental. Well, they had high compliance rates with registration. They were kind of proud of their high compliance rates with all these people who are required to register, and they had a pretty high compliance rate with the registration. And they considered the mandatory minimum to be instrumental in that. So, and in fact, there was a minority report that they issued on that group. The group had recommended getting rid of the mandatory minimum, and the minority report from law enforcement was basically, this is really helpful to keep people in compliance. So I think that is a I think that's supposed to be a public safety factor. I'm not sure.
Yeah, that would be.
I'm not sure what the evidence is that, having that the whole system really assists public safety. But
Well, and like if I can piggyback on that, in our subcommittee, what we talked about was the registration system is really the mandatory minimum. Maybe we're not sure, but the system is really good at getting people to register. But does that prevent future offending? I don't know.
mm-hmm.
I don't honestly know if there's a link there. And I think we would need to know if people are registering because of fear of the mandatory minimum
Mm-hmm.
or not. So, and we've also, there's a research report that the Rabina Institute has done. It's really just a summary of research that's out there that talks about registration schemes in general. And I should have provided it to people, but that really says registration systems are really good at registration systems,
Mm-hmm.
but they don't have a relationship to offense rates. So I just don't, I think I'd like to know what's the purpose of the mandatory minimum.
Well, I mean, I think that begs the question, what's the purpose of the registry? I mean, is it to deter the people on the registry from committing crimes? I thought it was to assist law enforcement, you know, so like there's been, somebody jumped out of the bushes and did a terrible thing and we don't know who that is. We need leads. Quick, let's look at the registry and see who lived or worked in I'm not a law enforcement agent, but in an X mile radius of that location. And sort of canvass those folks and see if they have alibis for that time. I think that's what it's for. I'm not sure. And I don't know if it's ever successfully been used to apprehend the guy jumping out of the bushes in the past, so it's if that is its purpose, it's a pretty big system. And these are kind of big punishments for something that I don't know that there's evidence to support its success in that regard.
And now I'm going down a very far rabbit hole, but as the DOC rep here, what I can tell you is that I hear from our providers who provide sex offense treatment like all the time that they don't have enough to do their jobs. They don't have enough funding to do their jobs. We're putting a ton of funding into the registration system and not into treatment, which is effective at preventing future behavior. So I get really tied up in this whole thing. Like I'm not saying that means we have to do away with the whole system, but if it's a law enforcement tool, great. Let it be a law enforcement tool, but also fund the things that are going to prevent crime in the future. Because if it's law enforcement tool, it's a reactive tool. It's already after the behavior's already happened. It's not going to stop or prevent future behavior, which is what I always focus on. Mark, did your team talk about what else we need to know on public safety?
Yes. And one of the things was if we could know what the time delay between registration and that first offense is on average and how that impacts the mandatory minimum was one. And another was which regulatory requirements are being violated. In other words, is it, a total failure to register, or is it more of a technical violation of, the not having the school phone number right, or not having it on there, or having, less important information not reported.
And on our front, on the stakeholder input subcommittee, the question that I already posed of do people register because they're required to or because of the mandatory minimum was what we wanted to know more about. And I've already, I think, articulated what we talked about with public safety, except the last piece was, from the victim perspective, there's no mandatory minimum for first-time criminal sexual conduct, but there's a mandatory minimum for first-time violation of registration, and that doesn't, sit right or feel right from the victim perspective. So that it just feels like a mismatch there. And if it is the law enforcement tool, we also talked about this as being a law enforcement tool, not an indication that the person has caused harm. So the fact that CSC is armed and being treated differently, was just a point that Ashley really eloquently made, and I'm not making as eloquently as she made it.
Which I think it probably technically goes under B, right, Mark? I mean, that's a proportionality argument.
Yes. Yeah, and I was combining those.
No, I'm just pointing that out because you probably talk more about proportionality as well, or did you have anything more to say on that? Oh, I'm sorry. We-
Yeah, on proportionality, one other thing that came up was the amount of discretion that's in the hands of law enforcement that probably creates disparities
Mhm.
in terms of reporting that, the violation through and when they do that.
Well, and on the part of prosecutors, right? I mean, it's,
Yep.
I mean, because I definitely had that couch surfing case as a prosecutor, and I'm like, a year, it just doesn't seem. I don't know. I don't know if there's a way to like somehow, you don't, I guess you'd have to amend the statute, but somehow bake in, sort of think about what do prosecutors think about when they decide whether to recommend a departure here and bake that in. I don't know. Do any of the prosecutors have any ideas on that? Like, is there something we could?
I can maybe comment on this. This came in, I had some comments about the frustration with the mandatory minimum scheme, only how it was overlaid onto a statute that had many different types of things that could be offenses. The just completely absconding from the requirement to some technical violations to the offense leading to the registration. Say you had a prior sex crime versus a misdemeanor domestic that was a part of the circumstances with a registrable offense. The time since you committed that registrable offense, how many times you violated the provision, just some factors. And it seemed to create a system where it's just asking for departures and then viewing the statute, not the mandatory part of it, as not a tool to be imposed. I would rather, if it were up to me, focus in on the very core group of individuals we want to know where they're at, and then have a mandatory for them. So you're asking which factors. It's kind of all those things, it's, did you have some lesser offense that led you to this requirement and things couldn't be changed? Is it technical violations, etc.?
I mean, it sounds very complex, like
Just like the statute.
Oh, yeah, the statute. I mean, it is daunting if you have, I guess we didn't put in the record, the sort of the initial notification sheet, where they check off all these things. I understand this and this and this and this, and it's, it's a full page of fine print that, somebody who's maybe got other things on their mind since they just been sentenced for a sex offense or something, but they have to go down this big list and say, yeah, I understand all that stuff and I agree to it. And,
Nate,
yes.
I think the data kind of supports what Shane just said, and you'd mentioned this earlier. And first of all, looks like this mandatory has the highest overall mitigated dispositional departure of the ones we're looking at 52%.
Yeah.
But then when you look at criminal history score, for zero criminal history score, the departure rate's 89%. For 1 point, it's 70%. Clearly, judges are seeing that, making that call about maybe not seriousness of the underlying offense, but.
Well, I wonder how many people are on the registry with a zero criminal history score. That seems
151.
I think that sort of goes to what Professor Osler was saying on time between the offense that triggers registration and the failure to register. Because if you've gone so long that that's decayed. So another thought I just had that we didn't talk about in our group is to keep in mind is this is also a statute where if you're a level 3, then you have the mandatory 10 years of conditional release on top of this. And if you're a level 3, you're also automatically on ISR. So you're on the strictest supervision in the state. And so sort of the worst of the worst are going to be under even more of a microscope than someone who's not and is just doing a year and a day and then they're done with supervision. So
Shane, does level 3 factor in at all to proportionality? Like if I don't think I've ever had a case with a level 3.
Yeah, I don't recall that either. And that's oftentimes after they've served their sentence, that's when it gets assigned.
Mhm.
Oh, just on the other data, the other point to keep in mind with the departures is that data does not account for stays of adjudication either, because that's not a departure. But
Mhm.
that's certainly a tool we've used in those most egregious kind of fact scenarios.
Mhm.
So in other words, you might have charged offenses and the number of either departures plus stays is even a higher percentage.
Yeah, that is true.
That-
Guidelines data only deal with convictions and sentences. Rob, you've had your hand up for quite a while. Dr. Stewart? Oh, no, you're mute again.
Sorry. I have a quick clarifying question as it relates to, post sentence, what is it called? Conditional release, right? Is that just for level 3 people?
Yes, if you're convicted, it's a 10-year conditional release. And I think a lot of times you see in court, people will say, oh, it's just, additional period of supervision. It's treated the exact same way as all other supervision in Minnesota. And if you are on there as a level 3, as I mentioned, like you are on intensive supervised release for 10 years. So it's treated the same as parole, essentially.
But there are also, Rob, there are also sex offenses that if you, particularly egregious or particularly bad criminal records of prior sex offenses, for example, that you'll be looking at under 609-3455, you'll be looking at 10-year or even lifetime conditional release for some of those sex offenses. So that's a separate conditional release that you could have.
Yeah. I mean, I just, because I was thinking of that when thinking about also this, like the overlapping of these different things. But I guess, to the point that I think Kelly or someone had brought up earlier about the research on this. I mean, this isn't my particular area of expertise, but in terms of like the meta reviews or the, kind of the reviews of this kind of stuff, generally speaking, in terms of like preventing recidivism, I don't, my read of the research is that there's not really a lot of convincing or actually much at all convincing evidence that registration requirements are really effective at reducing or preventing recidivism, particularly like this, like similar course of conduct type of recidivism. However, there is some mixed support for the law enforcement element.
Rob, I'm just going to interrupt you. I would say that this category, Rob's comments right now probably belong under category A, under public safety, preventing recidivism. Sorry, just for note keeping.
Oh, sure.
Go ahead.
But I would say that there is some mixed support, at least in terms of like research evidence that have looked at both like natural experiments and quasi experiments where there is, I think to the point that was brought up earlier, and I'd love to hear from law enforcement about this, but that it can be helpful for law enforcement purposes in terms of monitoring people or being, knowing where people are that they can go to. And I mean, so I in terms of a public safety part of it, like I think I could see support for a public safety element of it if it's through, like indirectly through law enforcement, through assisting law enforcement. But the other thing that I think is important to consider is, Minnesota is a bit of an outlier in terms of the scope of the predatory registration, like who falls in, who's eligible, the criteria that puts people into predatory registration compared to other states. Most other states tend to limit registration, these types of registration things with, people convicted of sex offenses or like kidnapping minors and stuff like that. But like Minnesota has kind of a lot, it seems like has a lot more things that could get you into this. And so I was thinking about Shane's point about, being, potentially focusing on the people that we are really kind of thinking and concerned about, relative to maybe some of the other people that because, so in other words, there's probably a lot more people on the predatory registry, you know, in Minnesota relative to what it would be in other states. And so you get this dilution effect because you have so many people on this, under this status, that you might not be, might not be able to recognize which is the subgroup that maybe is the one that we're most concerned about, if that makes sense.
All right. Any other comments that you had on proportionality, Mark?
Nope, I think that's pretty much it.
I would just say one more thing on proportionality, and maybe this is duplicative of what the vice chair said, or maybe it's, maybe it amplifies on it, but you know, there is the, you know, not only is this carry a mandatory minimum when crim sexes don't, but it might be a felony when the underlying crime that put you on the registry is not a felony. So, I mean, there's no proportionality test in this mandatory minimum vis-a-vis the underlying crime that put you on the registry. And I don't know if that's a problem or not, but it seems like it is. I mean, it seems odd to me that you could be put on the registry for, you know, maybe committing a misdemeanor right? I think if you commit a misdemeanor in conjunction with a registrable offense and the registrable offense is dismissed, but the misdemeanor is convicted, then you're registering, right? And so that misdemeanor could,
Yes.
you know, so that's a sort of another proportionality issue that at least bothers me. I don't know if that's, if that's, you know, consistent with other people's sensibilities. All right. And I know we're spending quite a bit of time here on proportionality, but I think that is this particular mandatory minimum, I think, is ripe for discussion on the issue of proportionality. All right, let's move on to equity and disparities. I guess I'll ask you to lead the discussion, Dr. Stewart. I know you didn't meet as a subcommittee.
Well, I guess my personal view on or like my own view on this is that in terms of equity and disparities, I'm particularly focused on geographic disparities because of the ability, you know, there's a lot more resources in Hennepin and Ramsey County than there are in Beltrami or Steele or, you know, Jackson or whatever. And so, you know, I think that's true when it comes to, definitely when it comes to access to, like, you know, sex offense treatment or relative or related treatments approaches, or even access to things like batterers intervention types of domestic violence things. And frankly, drug treatment. I mean, there's a lot, you know, there's a limited number of drug treatment centers in northwestern Minnesota that will take people with, you know, any kind of violent history. And so those are the geographic concerns is what I'm most focused on with this.
And I would just, to piggyback on that and sort of tying in with what Shane had said earlier, it seems like the way the statute is working, and maybe not the way it was designed, but the way it's working is basically it's putting on the prosecutor the burden to say, you know, sort of evaluate all those factors that Shane was talking about and say, well, you know, is this really the kind of case where this defendant should be going to prison? And that sort of high amount of discretion, coupled with a mandatory minimum, seems like it does beg for geographical disparities. You know, by prosecutor, different people are going to have different perspectives on this. I mean, I assume some prosecutors are just going to say, yeah, no, it says mandatory minimum, so you're going away. So, and I don't know if we have the data to support that. I should probably check the sheet. All right, anything else on equity and disparities with respect to predatory offender registration? All right. Good discussion. I'm checking the time. We got a little more than an hour left. So let's roll on to impact on victim survivors. Vice Chair Mitchell.
All right, so, for first of all, in terms of, how well does it accomplish its goals, I already mentioned the sort of the proportionality concern that we talked about with victims, feeling like this might come down harder on the registration requirement than on the actual underlying offense. With first time CSC not having a mandatory minimum. So we put that in sort of both places, both public safety and impact on victims, because it's a perspective thing. But on the flip side, there was some discussion about, victims might have the perception of like, well, how hard is it to actually register? Like, it's not a big ask. So it seems like they could do this. That's like caveating like all the stuff that we know about people who might be struggling with homelessness and all of those things, which does sometimes make it harder. In terms of what else do we need to know? We wanted to know, how often does someone who didn't register commit new or additional violent crimes? Specifically, who offends when someone is off of supervised release? So that's the point that you were making, John, that, the folks who are actually the most dangerous usually go to prison, do have a lengthy supervised release term, also have a conditional release term. So we know where they're at. They have an agent who supervises them, and we know where they are. So I don't know that we need this tool for that. So really what we're talking about it being an effective tool for is like after that stage.
Vice Chair Mitchell, just another point on that. There's also an enforcement mechanism, right? They don't need a mandatory minimum. You can just take them back in.
Yeah,
right?
well, that's correct. Yeah, I mean, it could be a violation of their supervised release.
Yeah.
Because keeping their agent up to date on where they're at and having an approved residence is also a condition of release. So, yep, there is another enforcement mechanism.
If he's obeying the law, which this would be a violation of the law. So.
Exactly. It's also that. Sorry, this is tiny, so I'm trying to read it. We had a lot to say, so the type got very tiny in our thing. And then we were also saying, who were the people? We also talked about the disparity aspect, like who is actually coming under this? Is it that one of the concerns was that maybe people that don't have access to the same level of legal representation who are mostly falling in this category, and that it may be falling disproportionately on people who don't have the means to be better represented. So that was another question that we had, is like, who's really figuring out a way to get off and who's not. That's it for D. I can move on to E whenever you want.
I would actually like to move back to C if I can. I'm looking at the data that the Sentencing Guidelines research staff presented back in January, looking at table 5, and it is borne out by that table where you see there's quite a bit of difference among different racial groups as far as and geographically, which I'm going to tie those two together, because the lowest, the rate ranges by race from 67.5% to 35.5%, which is huge. And then and the lowest, sort of the people who are getting stuck with the mandatory minimum the most, I guess, is the American Indian group. So you're probably not going to be surprised to learn that if you look at it by judicial district, it ranges from a high of 60%. It looks like the highest, generally tend to be in the metro area and the 3rd district, which includes Rochester. And then it goes down from 60% down to 35% in the 9th district. which, has the highest percentage of its population being American Indian. So you end up with some definite geographical and racial disparities there. So just
I
wanted
just
to
wanted
put that.
to add,
Yeah.
just to complicate things even more. We, like Kelly and I were talking about earlier, there's also some residency restrictions. So people who are on the registry, I mean, I don't know, Kelly. It seems to me that a lot of people do end up in the metro, even if I shouldn't say like,
Yeah, it's
I don't
one
know.
of
I
the,
feel like I
there's,
hear a lot of people, yeah, people in the rural, some people in rural areas will be like, why can't they live in St. Paul? And then people in St. Paul are like, we have families too. Like, so, yeah, anyways, go ahead.
there are a lot of residency restriction ordinances across the state. There's a long list in that POR report that you provided to us. And then, and I know for a fact that since that report was written, additional cities have also enacted ordinances. And some of the geographic disparity is really forced, right? Because people can only live in so many places, and the metro does disproportionately maybe get some of those folks, even if they would normally go, like for us, if they would normally release outstate, they end up having to release to the metro because that's where they can find housing.
Well, and that also adds to the basic problem of committing the crime, because it's harder to register if you're limited on where you can live.
Yeah.
Yeah. Adds to the challenges. Okay.
And just to my original point about the geography thing with resources, I mean, I've done a couple of years of research focused on Beltrami County and Cass Lake, or Cass, that kind of area. And so the 9th Judicial District. And frequently we would see people in court who would, be required to go to treatment or go to like drug treatment or some other type of thing, but can't because there was only like one treatment center that was within 100 miles or something that would accept people with some type of violent crime history. And so they would have to be sent to like the closest place to go was Hennepin County. And so you see a lot of people then being sent down to Hennepin County to do these things, but then they get out, and then, if you have to register from that point, you could imagine, it's not exactly where you're from. You don't exactly know where to go, and, those types of things. So those are all kind of parts of the issues that I'm concerned.
Or even if they're going back to Beltrami, then you have to do a community notification meeting because they have that registration level that requires it, so then that bars them from getting back to where they would normally reside. And they would have already been over that hurdle the first time if they hadn't had to go back down to Hennepin.
Okay, go ahead with, sorry.
Also keep in mind on the resource issue, it affects enforcement too, that lower levels of law enforcement resources in rural areas will cause investigation into these kinds of situations to be less. Too.
Interesting.
Jeremiah?
Yeah, here in Canyon High, it's kind of like they do it every several months or so. They have a timeline, they run through their list and then come back. And we at least have a fairly good sized department in rural Minnesota.
Yeah. Jeremiah?
Yes, I guess I would just the one thing to talk about is we talk about resources, and obviously, as you get into the metro, there's more than we talk about rural or outstate. But I'd be kind of curious to look at a sense of like what that looks like if they were to have resources up there, if that's going to change our perspective on mandatory minimums. And if that's the case, then I kind of look at a sense, maybe it's really important that we would focus that in our report, that we talk more that the resourcing can absolve this versus, getting rid of a statewide system, or kind of the laws and legislation we have now.
Right.
I mean, you know, I would say that plus the what we were just talking about, the ordinances or whatever, right? Like restricting people where people can live. But I would be really curious to hear, like, from Jeremiah or others who work with these registries, like how this isn't really right with the box we're in, but just about how effective this is in terms of investigation with this kind of stuff, and from a law enforcement perspective. Because my sense had been kind of similar to what Shane described, at least for, you know, I'm from a small town in southern Minnesota, so it's like it seemed as if it was like once every like handful of months there would be kind of like, okay, let's go through and just make sure everybody's where they're supposed to be, and or where they said they're supposed to be. And because, you know, it's hard, I think, in a smaller town in particular to kind of keep tabs on all this. But I'm also thinking about the kind of like in terms of in the midst of an investigation for a certain thing that happened, you know, how and, you know, to what degree these types of lists or registration lists are used and how important they are.
Yeah, I can
Yeah, I
talk on
guess.
2 recent cases. Sorry if I cut somebody off. I can't really speak to, you know, like we have a crime and we pull the people that are on the registry in the area and we've solved it via that. But we have 2 very recent cases where in doing the checks, we do the POR checks at least once a year. We're trying to do it more frequently. In one case, we found a female that was being trafficked and she was living out of the car in the driveway where this guy was living at a group home. And that was one of the charges he was a POR for. In a separate case, we had a male with the juvie in a hotel. He was a POR. He had a undocumented phone, and then on that phone, he was manufacturing, you know, while he's having intercourse with the juvenile female on that phone. So those are 2 very recent cases in which the registry helped us develop new crimes that these people are still doing.
Yeah, I was just kind of piggyback that. I think a lot of times we think about this list and we think about, you know, the guy that hops out of the bush is kind of the example that was given, and that's going to lead to solving this. But the reality is it allows a really good opportunity to create a lot of checkpoints to make sure these people are actually abiding by some of the terms that they can't be doing anymore, kind of as Nick was talking about. And I don't know how we would necessarily find that versus going through every one of these reports to figure out how law enforcement had contact with that individual, which I don't think we would have time to be able to get through all that.
So Jeremiah or Nick, I'm curious to know how do you think the mandatory minimum plays into that? You know, because it's not like the mandatory minimum is necessary for the system to be in existence.
Yeah, I guess I will say, like, limited experience in regards to that sort of stuff. I know for a long time, you know, in certain counties, depending where you're at, you would find that, you know, if somebody was non-compliant on registry, you know, if you were to arrest them for that minute they got into booking and jail, they would get a new packet, they'd fill that out, and then charges would get dismissed or dropped or that sort of stuff because they would say, well, now they're in compliance, so we obtained what we did. And so when we have things like that, once people figure that out, right, and know, like, oh, I'm actually not going to be held accountable for it, and we take away that, then it's not a big deal when they get caught not being compliant there forward.
Okay. So the threat of a new felony isn't sufficient. It's you think you'd have to have the threat of the year to make that work? Or
Well, I think it's the enforcement action, right? So if they're found in violation and then because they were booked and now we fill out a new packet, now there's some attorney's offices that would look at that and say, okay, well, now they are compliant, so we're not actually going to charge them because we got the ultimate goal of their compliance. Well, I mean, that just breeds into them that it's like, okay, well, I can just continue this behavior because there is not actually no enforcement of the law. And if we don't enforce certain aspects of law, right, people are going to say, okay, I can do this.
Sure. Yeah, I just don't see how that necessarily ties into the mandatory minimum specific. Like, I feel like that's a problem with or without the mandatory minimum, right?
Yeah, I think we agree. I think as long as there's some kind of punishment when you're violating, the rules of registration, I guess I can't say that we need to have a mandatory minimum, but as long as there is some accountability, I think that would probably be good.
Well, really good discussion. We probably should move on to E, Vice Chair Mitchell.
Okay. So functioning and feasibility.
And maybe we've been talking about E, right?
I know, I kind of feel like we had, like, I'm looking at my notes here and it's a lot of the things that we have already talked about. On the one hand, the one thing that I haven't said directly in this way is, one question that I raised is like, is it more of a strain on the system to track these folks just because, like I said, the folks who are more violent are already under a significant period of supervision, during which time we do have eyes on them and we do have a probation officer keeping tabs on where they are. So we're really talking about the time after that's different. And by that time, you have people who might be getting up in age and aging out of crime, and no longer presenting the same type of public safety threat that they might have when they were younger. So it's a big system for tracking, for adding a layer at a stage that's so far down the road. So I'm not sure if the mandatory minimum is needed for that. And then we just talked a lot about the barriers that people face in transitioning back to community, that once they're on the registry, and especially if they're required to register as a level 3, it creates a lot of instability for those individuals. So it's kind of the antithesis of what we need for rehabilitation, which is stability. Like we need the person to be able to create a stable life in order to move forward without reoffending. But this puts a lot of barriers up that can actually interfere with that registration. I guess what I'm saying is these requirements impact housing, their ability to access jobs, all of those other things. So the mandatory minimum is sort of piling on in that case, because they're already facing a lot of barriers to becoming more stable in the community, and the mandatory minimum is kind of piling on. So I'm not sure if it's functioning in that regard. Again, we separated that out from mandatory. The whole registry system is a law enforcement tool. We recognize that that's another purpose there.
And maybe this doesn't fit in this category, but I believe that if you are a registrant and you get convicted of failure to register, you get 5 years added on to your registration period.
Yes. Yeah.
So that's
Correct.
kind of its own.
Correct.
Its own mandatory minimum. I mean, I would imagine from a disincentive point of view that's pretty huge. I gotta mess with this paperwork for 5 more years now. So I don't know.
And then I'll get like really into the weeds, but also I'm trying to think how many. So I as assistant commissioner at DOC, I supervise the risk assessment and community notification unit. I think there's 13 people working there. So we have 13 people on our end working on this system. BCA has, I don't know how many people on their end working to keep the system going At the same time, I literally am getting phone calls every day about treatment providers who can't keep their doors open. I really find it difficult to justify the resource allocation in that way. I really wish that we would think about doing that differently.
Okay, so moving on then to speaking of resources, Dr. Stewart, would you lead us through F, fiscal and resource impact?
Sure. I mean, I think we've discussed a lot of the issues with resources, right? I think we've talked about the like the examples that have been given of when it's been used and used successfully have been also, based on infrequent checking, right? Like, so, which I don't know, I guess I think about some of those things as like, having a law enforcement do this versus say like probation, which I think is, but that's the, I guess neither here nor there. So I guess I would just say, I think there's the resources used for this, whether these are useful, because I think we're having some issues with the potential public safety benefit of not of the registry necessarily, or of the, the punitive aspect of it, but like the mandatory element of it itself. So, yeah, that's, in terms of the, whether those costs are appropriate considering some of the variation and the geographic and other disparities that we looked at.
Mm-hmm. And then Dr. Osler or Professor Osler, you want to lead us through G, unintended consequences and risk?
Can I ask a
Sure.
quick question about F before we move
Yes.
on? And
Sorry.
Sorry to keep putting you on the spot all this time. But if someone had a mandatory minimum, either, I mean, if it's the year or 2 years, they'll have 8 months or 16 months. Would DOC even bother trying to get those people into treatment beyond the fact it seems like treatment in the institution's pretty jam-packed as it is?
Yeah, no, not for this. The reality is that the only sex offender treatment that we have in-house is similar to an inpatient treatment. It's the most intense type of treatment. So anyone who needs something less than that. So number one, if it was that short sentence, they wouldn't have long enough to complete that, so they wouldn't get in. And then anyone who needs treatment that's at a lower level than that won't get it while they're in DOC, and then the strain is on the community side. So no, coming back to us will most likely not result in them getting it in treatment.
All right. Thanks. Back to you, Mark.
Yeah, so there's overlap with things we've discussed already, and some of the unintended consequences would include potentially exacerbating housing insecurity, that the broad net may minimize the focus on more serious offenders, and that law enforcement discretion creates disparities. And then one that wasn't discussed before is that, and this may have been an intended consequence, I don't know, but that it drives pleas to lesser offenses.
Mm-hmm.
Oh.
And I think that potentially is more true in some counties than others.
So the sort of the overriding leverage issue that kind of pops up in all these mandatory minimums.
Right. I mean, it's so common that you have to wonder if it was intended or unintended, but it definitely is there.
Mm-hmm. Yeah. Well, that's we're going to be talking about drugs shortly, but I mean, that's why, for years there was agreement that Minnesota's drug sentencing scheme was off, but nobody wanted to do anything about it because, prosecutors had so much power basically under the existing scheme that they really didn't have a huge incentive to come to the table. Until 2016, so I'm just going to segue into drugs. Until 2016, when there were some major revisions. So essentially what happened in 2016 in terms of mandatory minimum land is the mandatory minimum for second or subsequent controlled substance crime, which was a hard mandatory, still is a hard mandatory, non-waivable, that was scaled back significantly. So it only applied to first and second degree controlled substance crime, and the prior had to be a first or second degree controlled substance crime. It was much broader than that, and had a much bigger impact. So this is definitely the junior version of the second or subsequent, or the subsequent controlled substance crime. And then we got two new mandatory minimums out of 2016. I just want to kind of point out, for purposes of thinking about how things are going to work in the, what our recommendations are going to be, these mandatory minimums are different than other mandatory minimums that we've been looking at, because they're tied into the sentencing guidelines. And because they're tied into the sentencing guidelines, they take into account at least some consideration of the particular defendant. So a first time, a person who's never been convicted of any crime before is still looking at a lengthy mandatory minimum for aggravated first degree controlled substance crime, but not nearly as long as somebody who's got a very long criminal history. That person's really going away for a long time. And, as we see in the data, aggravated first degree controlled substance crime was sufficiently tailored by the legislature in 2016 when they created that crime, that it really doesn't occur that very often. So we don't see a huge impact of that crime. That's so again, Vice Chair Mitchell, would you mind leading us in a discussion of public safety on that? And just for time check, we've used up most of our time already at the meeting. So
yeah, so I'll just tell you what our committee said, and then we'll see what Mark's committee said. So for our committee, the question is, how well does it accomplish its the domain's implied goals? And basically, we're trying to figure out what the goals are. So if the point is to stop the drug trade, we don't think mandatory minimums work for that. There's always somebody else who can step into that place. And then the way that our sentencing is set up, there's not a lot of differentiation between sale and possession. So it's really hard to know like who's in it for the criminogenic need and to make money, and who's in it for other reasons. We didn't really have much to say about what else do we need to know. Mark, what do you guys say on public safety?
Yeah, I think for our group, which, it was pretty great, because we have the defense perspective, a prosecution perspective, judicial perspective, plus me, whatever I am. But it was interesting. I think there was consensus that these don't create a deterrent effect, but there was voice given to the fact that it does provide incapacitation in a way that is effective. One thing that undermines the way these address public safety is that the amounts have gotten higher that we see in these cases, the real amounts as opposed to the charged amounts. And so that's going to skew the effect that these mandatory minimums have on public safety.
Can you just explain that for me, Mark? I'm not sure what you mean.
Yeah. Well, just that it was rare previously to see 1,000 pill case. Particularly in meth, we had to change from, mom and pop cooking it up in the backyard, and now what people are carrying. And a lot of times that means that who we're getting is mules with, huge amounts.
Right.
So in other words, the mandatory minimum hasn't adjusted to, and frankly, the narcotics statutes as a whole haven't adjusted to how the trade has changed. That raises a bigger question, of course.
Yeah, I mean, I think it raises a question, particularly with so there's two mandatory minimums. There's the 85-month mandatory minimum, which is hard, and applies to aggravated first-degree controlled substance crime. And I'd have to look at the elements of those aggravating factors, but I think that's the kind of thing that shouldn't necessarily apply to a mule. And then you've got the high amount first degree. So these are like higher amounts than just even the regular first degree level. That's the 65-month mandatory minimum or more. And those I think would apply to mules. They are hard for sale. They're potentially soft for possession depending on your criminal record. But they are hard for sale. So I think your mule would probably get stuck with at least the 65-month. Am I wrong?
Yeah.
I mean, maybe that's what should be soft is the 65-month. Maybe that's the recommendation, you know?
And I mean, you know, this is beyond the scope of what we're doing, but you know, for years I've been arguing that amount of weight isn't a good metric for relative culpability, that the amount of money people make off of it is a better metric, and there's ways to measure that. But you know, that's what the statute we're dealing with is rests so much on weight. We have to deal with the problems that causes.
It's interesting. All right. Anything from any individuals about public safety regarding the drug mandatory minimums? All right. Let's see. All right. And then, Mark, do you want to lead us through legal purposes and analysis, the fairness and proportionality?
Yeah. You know, I think, again, you know, the what we just discussed, I think applies here too, that because these mandatory minimums are tied to weight, that doesn't mean we're getting the most culpable people. We're getting the people who are holding. Also, you know, in the context of this discussion, you know, we talked about having the guidelines match, insofar as the guidelines match the mandatories, that the waivable ones that may not have the need for the mandatory. One thing that we discussed as well was that there's disparities that are created by the pleas that we see in Hennepin and Ramsey, particularly relative to other counties. And the final thing that I think there was consensus on, and a strong consensus, is that there shouldn't be mandatories for possession offenses. And that, in fact, because people plead around it, we don't see those very often anyways.
Mm-hmm. Well, I'll just share the Sentencing Guidelines Commission's experience when in 2015, they tried to present a package to the legislature that differentiated between first degree sale and first degree possession, and the legislature shot that down. In fact, the legislature's general reaction to our proposal was the 2016 Drug Sentencing Reform Act. So, but having said that, though, there is the rare and if not only distinction between possession and sale of the same degree is found here, where if the defendant has, depending on the criminal record, as I said, the mandatory minimum may be soft for possession of a high amount of drugs, whereas it's not soft for sale of the same amount of drugs.
Yeah. And again, part of the problem is the low thresholds that we have that allow for overlap between a use amount and a sale amount.
Yeah.
Yeah.
All right. So I guess moving on then to C, equity and disparities. Dr. Stewart. Some of that was discussed. Oh, you're muted, Dr. Stewart. Some of that was discussed by Mark Osler too, on some of the disproportionality, but
I mean, that's kind of what I was going to say. I think it's similar issues as to, I mean, I think there's going to be some geographic issues here. There's going to be some, you know, who has access to an attorney who can kind of wrestle with this, or has more time and resources to deal with this, in terms of, defense and whatnot. And I think they're probably, I mean, my sense of the Drug Reform Act and part of it was focused on some of the racial disparities that existed, continue to exist, I guess. So, I mean, I guess when I think of there's so few cases that this applies to, and it kind of makes me wonder, like, why do they even put this on paper? Because, I mean, it's a pretty narrow set of circumstances in terms of who would be eligible for this kind of thing. And I just think that my personal view is that the infrequency of this is just not worth even having mandatory minimums about.
Well, I mean, that's particularly true, the aggravated first degree controlled substance crime. But I mean, I think I would say the benefit of aggravated first degree controlled substance crime is it provides a place, a target for people's anger about drug kingpins and that sort of thing. And, that's not what 99.9% of, drug crime prosecutions are about. But at least now there's a category for which we can say, oh, well, kingpins are taken care of here with these mandatory minimums, which, by the way, very low departure rates on the aggravated. But if you look at disparities on the 65-month high amounts, you do see those pretty high disparities. Again, you see American Indians getting that the full brunt of the mandatory minimum more often than other categories, and you see the 9th, and in this case, the 8th. But the 8th is so small, it's maybe a data glitch. But they might not have had very many cases. But the 8th and the 9th have the lowest mitigated departure rates again. So you got the geographical and the racial disparities going on with the 65+ month high amount cases, and then for the
Is it just the first degree one that has the mandatory?
So they're all the drug ones are mandatory. The only exception is the high amount possession is potentially soft mandatory if you have a qualifying prior record. And I don't recall off the top of my head what that is, but it's potentially soft for possession only, possession of a high amount only. So if you've got the big box of pills or whatever, you could potentially get a departure from that, and it wouldn't be illegal. But yeah, and
I mean, that is another thing. I mean, I think, that's something I'm really interested in understanding, like how these things are operating in places where these are mandatories, but they're still getting departures. But I mean, I don't think we have the time or the scope to do that, but that in itself also kind of suggests that there's something going on within those cases. And so to me, that is a potential disparity issue because equity issue, because you don't know exactly what is leading to that.
What's the reporting requirement required of the judge on a departure like that?
Judges are required to submit departure reports. They're supposed to state the reasons for the departure on the record, and they're supposed to submit a departure report to the Minnesota Sentencing Guidelines Commission. And it's from that departure report that we get the data in those tables where the judges say what the reasons for the plea were.
Is it ever phrased in a way where it's a mandatory statute says they are not allowed to do that, where the question is phrased that way? Please explain the reasons why a departure was given in a case requiring a mandatory sentence.
So our query in the Sentencing Guidelines Commission is not why did you violate the law? It's why did you depart from the sentencing guidelines? So that's the question that we're asking. I mean, it's a fair question, Shane, but and again, this kind of goes back to the complications of mandatory minimums. It's complicated on two sides. If the judge agrees, if the judge does not impose the mandatory minimum, the prosecutor can automatically win an appeal on that. And if the judge does impose the mandatory minimum and there is any whiff in the plea deal that the judge might not impose the mandatory minimum, or that it was even a possibility that the judge wouldn't impose the mandatory minimum,
Yeah.
then the defendant automatically wins on appeal because the plea was non-intelligent and voluntary. So it's definitely a kind of a high stakes venture. But if a judge agrees to depart from the mandatory minimum, the prosecutor's okay with it. The prosecutor asks the judge to depart from the mandatory minimum. The judge does depart from the mandatory minimum, and the prosecutor doesn't agree with it, then it's fine. I'm not saying it's technically not illegal, but it is fine. Nothing's going to happen as a
Yeah.
result.
No, because I was thinking ahead as we're thinking of recommendations to give. I think this is kind of an area to give a recommendation on, is that the system should explain why it's blatantly violating the sentencing law.
Mm-hmm.
Or, or we find out if it's a education issue, training issue, because I can see like on some 60911 where you have possession with a gun and on drugs and it leads to what should be a mandatory, or the hard mandatories on first degree, second degree that aren't waivable, but based on a prior like offense. Is this system, like the guidelines review of a worksheet, coming back saying, hey, this requires a mandatory? Or does it not do that? So is there room there for changes in the system?
Yeah,
I can weigh in on that a little bit. And I think this is pretty consistent with what I've already heard. The form that we fill out for a departure does not say, why did you violate a mandatory? And I don't think the Sentencing Guidelines Commission is looking to enforce that. And I think, Shane, you're right. I think on some instances it gets missed. And then it's up to one party or the other to appeal it. But it's also the ones where state agrees not to appeal. And, early on in my career, I think I did that once and didn't like it and told the parties going forward I wasn't going to do that. We had to figure out a different way to get to the end result they wanted, rather than just saying everybody's going to disregard the law. But there is a range anyway of how acceptable or unacceptable that is. And I know that it goes on in other places, or even other judges in my place. But that's usually in my experience anyway, that's the situation. We all know that this isn't exactly what the statute calls for, but nobody's going to appeal it. So therefore it's just going to stand. And I don't think the Sentencing Guidelines Commission is in a place where they're the ones pushing back on the bench to enforce it.
Yeah. I mean, we're basically a data collection agency. We're not, we don't enforce anything. Okay. So let's kind of stay on that point if we could, Vice Chair Mitchell, and let's skip to, we'll just go out of order because we're kind of talking about system functioning and feasibility. So why don't you just lead us through any other insights you had on We've been talking a little bit about, particularly with the hard mandatories and how that affects system functioning and feasibility. Anything else that you had under E?
Yeah, I know we just again there talked about the fact that the mandatory minimum doesn't really differentiate between use, so people who are there because of addiction, and sale and distribution. So from that sense, which makes it hard to get the right response from the system, right? Like if it's addiction, then you really need to respond with treatment. If it's sale, then accountability is probably the right response in that case. So then it's not really working to sort the people that are coming before the court on this issue.
And in the data table, if you look at these various tables for mandatory minimums, you'll see that table 9 has the highest mitigated departure rate for possession. It's 42.4%, and that's the one where it's potentially waivable. For sale, it's 38%, and it's not waivable. So that's kind of goes back to the issue about these non-waivable. The other ones are closer to 20%, but 38% for sale, non-waivable high amounts. So
If I could though, I really would like to talk about the one above that, the victim survivors.
yeah, no, I didn't mean to skip that. I just thought since we're already talking about system functioning and feasibility,
Well,
let's talk about that.
It's sort of relevant
Okay.
because the other point that Ashley brought up, which I never would have thought, I just like didn't think about this, and it was the first thing that she thought about, is that they're like who are the victims and who are the the ones being charged. So number one, it's hard to identify who the victims are, except in like a case where an overdose might occur, and then it's the family is also the victim. But she also talked about people who are victims of abusers taking the fall for a drug crime that their abuser actually committed. She had an instance of an individual who was being trafficked by somebody else who was actually and was using using drugs to sort of keep that person in that position. So like the person being charged with these offenses could also be a victim of another system, something else that's going on. And then they're the ones getting these really harsh penalties. So there's also more nuance that needs to be taken into account, and Ashley could probably say something better than me on this point.
Yeah, I was just going to maybe add that I heard a story on Wednesday of on our action day of a domestic violence survivor taking the fall for a drug related incident, but also in trafficking situations, sometimes people are looped in because of addiction issues, and are, their trafficker is supplying them with drugs. And then also sometimes if, someone doesn't want, they're going to sell drugs that day, so they don't have to be trafficked that day. They don't have to be sexually assaulted that day because they're doing the drug related pieces of it. So, and that also exposes them to the risk of, being charged of a crime. So I guess that's kind of where I see the victims in these cases.
That's interesting because there's no, there are like, there was a bill this week, I think, to direct the Sentencing Guidelines Commission to create a mitigated departure factor for if the defendant was also a victim of a crime and that affected the crime. But there's nothing in statute. Go ahead.
Oh, okay. Yeah, it's the Survivors Justice Act, and it didn't pass the House, but we're hoping that the Senate might think differently about it. But it's been something that's at least in the legislature, but the legislature they've been working for a long time.
But I think that raises the question on these hard mandatories, and this is really the only time we're getting into it. Well, there are hard mandatories in 6911. It's just confusing to explain. But these hard mandatories, should there be an escape valve for hard mandatories under certain circumstances? And is this one of those circumstances? Is there even where a hard mandatory is appropriate? I don't know. Maybe like your drug mule. Is that if somebody was coerced to do it for whatever reason? Is there something where there's at least a legal out for the judge? So that you don't have to. Maybe it's something along the lines of the mitigated departure factors in the sentencing guidelines. I don't know, but is there a reason why even a hard mandatory shouldn't necessarily be hard? Okay, great. Let's. Mark, go ahead.
Yeah, just real quickly. I do think that there are victims of drug trafficking. I spent 5 years as a narcotics prosecutor principally, and one of the things that I found was the people who lived next door, the people in the community who were around where drug trafficking have their freedom and quality of life greatly diminished. And it's unfortunate that that doesn't get measured in very often when we talk about who are survivors or victims of crime, because they're not reached out to, they're not talked to, because there isn't that kind of direct impact. But if you live next door, it's 1997. If you were living next door to a crack house, that meant you couldn't let your kids out of the house. It meant, 1,000 things that normal people can do that you couldn't do.
Yeah. No. All right. Let's see. Rob, you want to talk about fiscal and resource impact on this?
Sure. I mean, I don't know what, there's not really over and above other types of just general drug cases. I'm not sure that there's a ton of, I guess maybe the prison piece, because if it's a mandatory, and most of them are supposed to go to prison, or all of them, I guess, they're supposed to, according to law, they're supposed to go to prison. That's clearly going to have an impact on the prison population. But as we discussed, it is a relatively small number of people that is in this group relative to the overall kind of controlled substance caseload. But it's going to be people that are going to be looking at some of the longer sentences.
Mm-hmm. Yeah, and I can't help looking at this from a pre and post 2016 perspective. I mean, the impact for these is a lot lower now than it was pre 2016.
I mean, I think that is a really good point, because the mandatory that existed with the pre 2016, I mean, that was a huge net, right?
It was.
Compared to this is a very, very narrow one.
Yeah, it's almost shocking looking at the data for the second or subsequent. Now it's just those numbers are tiny compared to what they used to be. Just narrowing down the criteria like that. Yeah, there's 52 cases of departures. Well, I guess it's more than that for total cases, but all right. And then Mark, you want to take us home with
Okay, yeah, I'll be brief here. For unintended consequences, one thing is, insofar as they're premised on deterrence, the fact is people don't know where those lines are, and that undermines deterrence, that those thresholds are odd and arbitrary. As I was saying before, that, in other states, they will have the major cutoff be an 8-ball, which is a breaking point that the people on the street understand. Second thing, unintended consequences, clearly the disparities that we discussed previously. And as well, what wasn't foreseen and hasn't been adjusted for has been the changes in the trade, particularly with meth.
And with that, we'll move to the thank you everybody for your work on this. I think this is going to be really helpful. I'm looking to see the write-up on it. To the last issue about complexity, I think that has to do with the subcommittee report outs. We were talking about, gathering information from stakeholders now, and Vice Chair Mitchell's going to talk about that. But, one of the issues of gathering information from stakeholders, like talk about 6-9/11, it's like people may not have any idea that their case was impacted by 6-9/11. It's not necessarily clear, how that affected a particular case. It's not necessarily clear to the victim. It's not necessarily clear to the defendant, that 6-9/11 was really involved here. So I'm going to let Vice Chair Mitchell talk first on the subcommittee report outs. I know she's got quite a bit to say.
I don't know that it's quite a bit, but
Okay.
it's
Well, I guess we don't have that much time, so
yeah, I got it.
can't be too much.
No, I appreciate it. So the stakeholder, last time I reported that we had been able to select a vendor to do the stakeholder engagement piece, but I couldn't say who yet because we hadn't signed the contract, but now we have. So it's the Minnesota Justice Research Center. We'll be doing that work for us. Our subcommittee and the chair actually already met, and Jeremiah joined us too. And we already met with the researchers from Minnesota Justice Research Center to do a sort of a workshop to try to help them get clarity on what we're looking for in that feedback. We did that earlier this week. And I think that went pretty well. It was really interesting to sort of think through what can we learn from the various groups that this task force has been asked to hear from. And the point that the chair brought up was really one of the bigger ones, that the biggest difficulty they're going to face is, we're supposed to find individuals who have either been convicted of a crime that was subject to a mandatory minimum, or victims or their victims or family members. And I just don't know that people realize or know or understand that the mandatory minimum is involved in the case. So that's going to be the real struggle to find that. We did talk about potentially having different approaches for different groups, possibly a survey for people in the criminal justice system for the practitioners, so that we can maybe get a little bit of a broader and more geographically diverse group of people providing information on that. We also have some information from the sentencing guidelines that I'm going to make sure that MNJRC also has, so that they can maybe pick up where that work left off instead of trying to recreate it. So maybe doing a survey with practitioners, but also opening the door for interviews if anyone is interested in doing an interview with them. Probably doing a focus group with people who've been convicted of the offenses, because that'll be a group they'll be able to reach more people in fewer instances if they do the focus groups. And then interviews with victims, because that's a more vulnerable group, and so we want them to feel very comfortable in sharing their stories. So that's the approach that they'll be taking. They are hitting the ground running. They will do their best to get us some feedback within the very short time frame that they have to do it. Is there anything else that you wanted to add since you were there?
No, I don't think so.
Mr. Chair.
Yes.
I should probably just disclose that I'm a board member of the Minnesota Justice Research Center.
Okay.
Well, it's good you weren't on the group selecting them.
Right? Not involved.
It's true.
Yeah.
Yeah. And I'm on their advisory board, so.
All right. So thank you for that. Any reports from Dr. Stewart or Professor Osler on your committees?
I put out there everything we discussed.
Okay.
I'm meeting with, so we were able to also get the contract settled or signed or whatever with Robina Institute to do some of the data stuff. And so I will be meeting with Julia Lazaronsky next week. And then Nate, I'm gonna meet with her. We're gonna talk about some things, and then Nate, I was gonna maybe reach out to you for the three of us to have a conversation just about what she should do separately, like what potentially the guidelines could do or has done, and maybe compile some of that and then kind of separate that out from what she would do.
Okay. Sounds good. Yeah, and rope Leah Bauer in on that conversation as well. She's my research supervisor. Okay, and then April and May agenda items, deliverable planning. I will just say my goal for April, I really want to turn the corner and start, we really don't have much time left till August. And I'd like to turn the corner and really start talking about ideas. Even I think we kind of met, some of the leaders of this group met, and we thought maybe one of the better ways to approach it would just be to kind of put something out there and just start discussing that. And we can obviously move in a different direction or whatever, but I'd like to start talking about nitty-gritty policy proposals, or at least sort of our general framework or structure for potential policy proposals in April. So I expect a really robust discussion in April about what should actually be proposed here. Spoiler alert, I'm not going to be proposing the status quo, so I will be proposing some changes. Just as a starting point for what I hope would be a consensus recommendation. That would be my ideal. I'd love to see a consensus recommendation from this task force. I think that carries a lot more weight with the legislature than a divided recommendation. So, I'd love to avoid minority reports if at all possible. It may not be possible, but I'm just saying that would be my aspiration. Julie?
Sure. I know that if we think about the grid that we shared in December, we've made some adjustments to those for time's sake, I won't share, but just moving some of the things back so MNJRC can give us data, knowing that they are still going to be doing data collection right now. And then also, the work that some of the committee meetings or members are doing. We have been doing background stuff to also get ready for reporting based on some of the things that we need to have set up. But yeah, so we can help Nate and Kelly and everyone put together some stuff for the discussion next time too, based on what the reporting pieces that we have established and kind of in the background from all these meetings. So I think we're moving forward. We're a little bit behind where we initially thought we would be, but we're still fine to be moving towards a report in August.
Excellent. Don, do we have any members of the public online?
We do not.
Okay, so we'll move on past public comment to the next meeting date, which is April 10th. So 4 weeks from today. We'll look forward to a good discussion at that time. Any further business to discuss before we adjourn? All right, hearing none, this meeting is adjourned. Thank you all for your time and participation today.